welcome to another edition of the LTC webinar series, and happy Cybersecurity Awareness Month, October Cybersecurity Awareness Month, as well as Digital Citizenship Month. So throughout this month, you'll see webinars from the LTC, both kind of split between cybersecurity as well as digital citizenship. So look forward to hopefully seeing you join us all throughout the month and through the rest of the school year. My name is Brian Bates. I'm the Director of Professional Learning with the Learning Technology Center. And joining us today is Brandon Wright of Miller, Tracy, Braun, Funk, and Miller. You may remember Brandon from about a month ago. Brandon joined us to talk about some of the legal issues that were surrounding the remote learning. If you did not have an opportunity to see that, please go back and check out the archive video on our website. It's listed over there on the screen, ltcillinois.org/events/webinars. Scroll down a little ways and you'll be able to see it under the on-demand video section. But I highly recommend going and checking that one out. It was a great session, and I'm sure today will be great as well, as Brandon joins us to talk a little bit about some cybersecurity. As a quick reminder, everybody's on mute. If you have any questions for Brandon throughout the session, please make sure you throw them in the chat. Don't forget to change the to who you're sending the questions to everyone or all panelists and attendees to make sure everybody can see the questions that are being asked. And we'll do our best to make sure we get them answered throughout the session. If you don't want to ask right away, but you want to wait towards the end of the session, there will be a little bit of time for Q&A. So you can send your questions at that time as well. We'll have a recording available later on this afternoon, again, on that link that I was telling you about a little bit ago. If you scroll down the on-demand, we'll have this posted later on this afternoon. If you're interested in the professional development credit for joining today, that'll be sent out tomorrow in the morning. So you can be checking your inbox for those tomorrow. So without spending any more time, I'm going to go ahead and turn it over to Brandon. Again, welcome, and thanks for joining us to talk about cybersecurity.
Well, thanks so much, Brian. I'm going to go ahead and share my screen real quick so I can flip over to my PowerPoint. So thanks for hanging out this afternoon, everybody. I know there's a lot of issues going on out there for us as we're getting back to school and thinking about all the fun things going on, but cybersecurity has to be high on that list. And I think that as we are all gearing up for the full implementation next July of our state Privacy Protection Act, and with remote learning, and as people are working remotely and learning remotely, I think this is a particularly important time to thinking about cybersecurity and some of the legal issues that pop up. So what I've tried to put together today for us, just to be a little more open-ended, and so we can certainly have lots of questions as we think through and think about the issues today, as I've tried to put sort of a top 10 list to give some structure to our conversation. So my hope and my intent is, as I walk through my top 10 list this afternoon, that you all have some good questions and discussion. So please don't be shy. I got the chat box up, actively monitoring that so that we can all be paying attention and learning together and sharing ideas. And so as you have resources or suggestions or questions, let's use the chat box for that purpose, and let's jump in. The other thing I want to say is, as a lawyer, and again, this isn't legal advice. This is an educational training and program, but as a lawyer, I'm not always the best expert in all things tech. I mean, I use all of the technology I need to use well enough in my practice of law and working with school districts, but there are certainly things that some of you who spend more of your life dealing with the ins and outs of technology may have some great resources. So that's why I hope this conversation can be helpful, where if you guys have good ideas, let's not be too bashful about sharing them. But I say let's jump in with the top 10 list and talk through some of these issues that we need to be thinking about. And so the first thing is recognizing that this is an area of the law and an area of practice for you all in school districts that are changing frequently. With all of the lightning advances in technology, what might have been considered state-of-the-art reasonable cybersecurity today is going to evolve. And so if we have a system that's 5 years old or 10 years old, is it still really effectively secure and meeting all the obligations that are there? And so as we jump into and think about these legal issues, I want to recognize that we have some obligation as school districts to continually and periodically assess what our cybersecurity practices are, both from the hardware and software side of things, from the training of staff, to make sure that we are keeping up to date with what is the most recent version of things and the most secure version of things. And I think that's an important starting point for us. And in that vein, we want to start with number one, and a very important starting point is the selection of the platform that we're using. We want to make sure that when we are selecting, platforms that we're going to use in the school setting, whether it's for educational use, for instruction or enrichment with students, or whether it's for more an administrative purpose, for bookkeeping purposes, for student records keeping purposes, for other data and information processing purposes, that we are, as school districts, maintaining a lot of confidential information. Certainly student records and student information is protected by FERPA, ISSRA, SOPPA. We could also go at the federal level and talk about COPPA and SEPA and all of the other acronyms of privacy laws that engage us in the school situation. But I think one of the most important and most effective things that we can do on the front end is the choice of platform that we're using. The choice of software, the choice of different applications, that becomes really important and really essential for us in thinking through those legal obligations and the legal issues that arise. And so I think it's very essential that we recognize that maybe not every program and not every platform has been built and designed to be used in an educational institution and with that type of confidential information. And so, I think that to the great extent, there's a lot of resources out there from the Department of Education's Office of Student Privacy, from trade group websites like studentprivacypledge.org, and information from the LTC and others that help us understand what types of platforms are using. And I think when it comes to our compliance with FERPA, with the Student Records Act, with SOPPA, with those types of legal requirements for protecting student confidentiality and making sure that our platforms have the right privacy protections built into them, by and large, it comes first and foremost with choosing the right platform. And I think that's the difference sometimes between free programs and subscription-based programs, between things that are meant for entertainment value versus things that are really meant for educational use. Those are really significant differences. I know, Brian mentioned our last webinar talking about remote learning, but it's hard this day and age to not revert back to and talk about remote learning in these conversations. But when we talk about student privacy and FERPA and student records rights during remote learning, 99% of the battle is selecting and choosing the right platform. Now, it's certainly not my place and not my intention today to, get into the specifics of different platforms or endorse or not endorse any particular platform. But I think that, all of them certainly have their various settings that we want to also be looking for as we choose a platform, and really being careful about knowing what can and can't be run securely on your network and what can and can't be used securely with students and others. And so if we're using, for example, a Google Suite for Education or other similar large platform, that there are certainly a lot of privacy protections built into it, but also user error becomes a huge factor in talking through and thinking through those issues. So that's got to be our first and number one, is the selection of the platforms themselves. Now, they also still need to be user-friendly, right? If we select the most, arcane, archaic, hard to use, not user-friendly platform, then we're wasting our tech resources, right? I mean, school districts only have a limited amount of resources to spend and use on issues of technology. We've got to make those dollars go far. So we want it to be things that people are going to actually use. And so that's a careful balancing act between those platforms. Let's just take it to a very basic, simple issue here. Communicating with parents. What is a safe and secure mechanism for doing that? Do we want to make sure that we're using, for example, a school-based platform like our school's email or other app or program supported by and owned by the school district? Or if we just have, school employees and teachers texting parents on their personal devices without any sort of protection or encryption as they're doing that. Those are the kinds of decisions we've got to first start with, helping staff understand which platforms are okay and which ones aren't. And I think the next step beyond that is taking a look once again at that, or our best friend, our acceptable use policy or acceptable use procedure. Now, I'm going to take a guess here, and we'll see how close I am on this. My prediction is that many of us listening and participating today on an annual basis have signed our name to our school district's acceptable use procedure or acceptable use policy. And my guess is we even did it again at the beginning of this year. But my question or my challenge is, but when's the last time you actually read it? I mean, how many times do we sign off on things because we know we're supposed to? But, that is certainly a very important one. Now, I think most of you probably use, the press procedures for that purpose. And, certainly as a lawyer, I like to read the things I sign. Sometimes that annoys people, including my spouse, if I'm going to be spending too much time reading an agreement before we sign it. But that's the curse of being a lawyer. But I think it is important that we are fully understanding where those limits are of acceptable use, what is unacceptable use, and that employees both understand and that we are enforcing it. Because that's one of the other concerns I think that pop up for me, is that it's one thing to have policy, but the reason why we have the policy is to protect the school district and school employees from liability and getting into trouble. And I think too often it's something that we do as a matter of form, and we kind of forget about it or don't pay that a close attention to it. I've seen many situations where school employees, whether they be teachers, administrators, or the tech staff in a school district, while they know the acceptable use agreement or policy or procedure exists, they kind of look the other way on it. And when you look at what really is acceptable use, particularly if you use the press procedure, it's a pretty limited window of what is and can be acceptable uses of the school district's network and equipment. It's really limited to an educational purpose or a school business purpose. And so I start to, ask school staff sometimes, if you're doing your personal Amazon shopping on the school's network, does that comply with the acceptable use policy? Or is it a violation? Or is it in that sort of neutral zone between what is acceptable and an unacceptable use? And where does that line drawn? And I think that it's important for us to help employees understand where that line is and what those rules are to protect them and protect us. Because if we get too lax in our enforcement, then employees start to, I think, feel like it's no holds barred in using the school district's equipment. And that's what opens us up to security threats. What opens us up, making it more likely that we have a phishing attack or other hackers or malware being downloaded and other things that go around the important security measures that school districts are putting in place. And so I encourage you to really take a step back and actually, as if for the first time, read that complete acceptable use policy and procedure that you have employees and parents and students sign off on each year, and then really think about what are the things in there that's working, that we know we're doing and we're doing appropriately. What are the aspects of that policy or procedure that we need to tighten up a little bit? And what are the things that we're totally failing on? And let's create a plan for moving forward with those, because I think that we need to recognize the importance of that policy and procedure. And again, if you're using the press procedure or some modified version of that, it's a very good starting point. It's those folks do a lot of great work that makes the life of school attorneys very easy when they're creating those very good policies. It's also a policy that's existed for a long time. And, and while it certainly has been tweaked over the years, it still certainly exists in the way that it did many years ago. And so my concern is that means that the longer it exists, the more attenuated we get from its initial adoption, and the more attenuated we get from actually having read it and know it and understand it. And most importantly here, as I note, enforcing it. So I think that's particularly important for us. And I think that understanding and enforcement of the acceptable use policy leads us plainly into number 3, which is having a clear and clearly understanding the process and written policy for what apps or software are appropriate and secure. And I think that this might be a piece that isn't as directly addressed in that policy. So, basically the issue here is who can download what and when. And I think it's very important that everyone who uses the school's network, employees, students, and everyone in between, knows exactly what those rules are. And this is also a careful balancing act, because again, the purpose of the school district's technology and platforms are to be able to be used to make education better and more useful and user-friendly, to make the administrative side of things, the data and information processing that we do as school districts, to make that more efficient and easier and better. I mean, that's what technology is there for us. And so I don't want this process or written policy to be so prescriptive that, teachers are saying, if I want to use a new software, it's going to take me a month to get approval to do that. That's not useful. That's not meeting our educational mission as a school district. But at the same time, if it's, no holds barred, where anybody can download anything at any time, again, that puts our district's network and devices at an increased risk for the threats that are out there. And those threats are real. I mean, certainly we've had a number of data breach, inadvertently or purposeful hacking situations in school districts where there have been identity thefts, extortion plots, lots of those kinds of things that have faced school districts, and we need to be prepared for that. And so often it comes back to, where the rules are about what can be downloaded and when. And so, this also has a connection back to our filtering software obligations, among some of the other obligations that are out there for us. And so there needs to be an easy to understand, an easy to implement efficient process about who can download what and when, and what that approval process is. And it's also important that whoever the gatekeeper is for that process is that they are also have the knowledge and skill set to balance the issues of security with meeting our educational mission. I know that, again, because it's hard to get away from remote learning or anything related to that in our conversations these days. But, I think that during this period of remote learning, where a lot of districts are using various forms of remote learning, it's also been a time of great creativity and discovery for how educators can be using different programs in different ways unexplored before, to really create some meaningful ways to educate students when they can't physically be at school. But that also opens the door new platforms, new sources of potential attacks, and new sources for loopholes or cracks in the fence of security that we've created for the school district. And so as we walk through and think through those issues, we want to make sure that we've got that clear, easy to follow process, and that it is in writing and that people are aware of it. And then number 4, we start to expand that out to those personal devices and networks. Now, I think this is true always, because I think that we recognize that educators are professionals who are always working at home and at school and at odd hours to do different things. But when we are accessing, school programs or the school's network from places other than being physically at school, we have to make sure that we have done what it needs to be done to maintain security in those situations. So for example, if I'm running the school's program, like the school's email or accessing the student information system or the IEP software from my phone or my device or my computer at home, can I do that safely and securely? And what are some of the issues that pop up with that? As well as not only the device, but also using personal or other non-school networks. And what I think is absolutely true is this is a situation where I get to give you the lawyer's favorite answer. Can a system be securely run on an unsecure Wi-Fi network? And the answer is it depends. It depends on your system and how that access is out. And so when we're talking about, whether it's, and just examples I've seen in the school setting where this has been an issue, whether it's a teacher accessing the IEP software from their home Wi-Fi, if it is the bookkeeper accessing the school's financial software remotely from home, to finish up some work. If it's a situation where a principal's at a conference and logging on to the student information system using the, free hotel Wi-Fi, all of those are situations we need to recognize, put our system and our network at potentially increased risk, again, for data breaches, security failures, hacking, identity theft, and those other concerns that are out there for us. And so it's really essential that we are training staff on, the how, when, where, and why of doing so and how to maintain that security. And as we know, with SOPPA coming into full compliance next July, and that every school is going to have to make sure that we've got those reasonable security measures for data privacy in place, that's going to apply not only in the physical location of the school, but when we're doing things remotely in the cloud from home. Is our home Wi-Fi secure? Are we using a WPA2 or WPA3 security? Have we changed the password? I mean, just very basic, simple things that are essential and important to maintaining those security protocols. And so many of the legal issues I've seen popping up where there have been issues where there's been a breach or compromise in the school district's network, sometimes that's coming from situations where it's not physically in the school building, but when others are accessing it remotely, creating some weak spots and some weak links in the chain that need to be improved and fixed. So I think those are really essential conversations to thinking through how those will play out. Number 5 is a big one. And it's one that we are going to have to spend a lot of time thinking about over the next, 9 months or so. And we know that the changes for our state law and SOPPA that go into effect July 1, as I mentioned several times, have specific requirements for what we do in the case of a data breach, the parent and student bill of rights for data privacy, making sure that we're using, reasonable security measures that meet or exceed industry standards. But among those things is making sure that our operator agreements with any of those third-party vendors or operators that are using or storing or accessing our student data, that we have agreements with them that meet the same requirements of the law of reasonable security protocols that meet or exceed industry standards, and that those operator agreements are going to have to be posted to our school district website starting July 1. So for those of you who are going to get the privilege, or might I say the honor, of being named the school district's privacy officer as required by SOPPA, one of those responsibilities will be making sure that not only do we have those compliant agreements, but that they are posted to the website. So that's the big picture. But how do we actually do that? I mean, so let's say we're using an online vendor, an online platform that's going to have student data. You know, their operator agreements are not just simple one-pagers, right? Those are sometimes very complex. And when we click accept or agree to that, how do we know that they are compliant without having a team of lawyers to review every one of them for us? And so we need to look at resources like studentprivacypledge.org, although while those are going to be federally compliant, you know, we've got some other more strict requirements now in state law. And so we're going to have to create a system of understanding who our third-party vendors or operators are for purposes of SOPPA, and what programs and platforms might have access to student data, or where we might be storing student data. And then making sure that those agreements are posted to our website and that that's a clear expectation. And I think that's going to also create a distinction and a clear difference between those operators who are geared towards and designed for K-12 use and those who aren't. Because those who are merely an entertainment app or productivity app that's not meant or intended to be used in a school are less likely to have those compliant operator agreements, or be less likely to make changes to their operator agreements to make sure that they are compliant. And so we know that between now and then, under the law, we're going to have to make sure that we are reviewing, for step one, who are our third-party vendors and operators that have the type of data electronically that are going to be covered under our SOPPA rules. Step two is going to be making sure that we have all of the agreements, the user agreements with those companies, including any subcontractor, and then reviewing them to make sure that they meet or exceed the security requirements and other data breach requirements that are within the statute. And if they're not, make them so then we can move forward, post those to the website, and make sure that we are meeting our obligations in that regard. And that's no small undertaking. And I know that right now our mental and emotional space is limited. And right now, I think for many of us as educators, as administrators, and certainly as our tech folks in the district, our physical, mental, and emotional energy, our financial resources are really being stretched to the limit right now with remote learning, our return to in-person learning, and all of those related issues. But there are some other legal issues that we need to make some space for in that planning and process. And, that ranges from everything from our massive Title IX training to everything else. But this is going to be one of them between now and July. That is, in my mind, not going to be a quick and easy task. And so I think it's really essential for the school district's privacy officers to be getting a start and getting a handle on this process now. Again, to start with, who are those operators or subcontractors that are going to fall into this category? Do we have a copy of the existing agreement? Have we reviewed it to make sure it's compliant? Get it compliant, post it to the website. Those are the things that are going to take some time and some mental and probably even financial energy and resources to get that accomplished. So that's a process we need to start sooner rather than later. And related to compliance with that statute and others, whether we're talking about SOPPA at the state level or COPPA at the federal level, we need to be prepared for a data breach. When one happens, and I think, despite all of the security measures you put in place, as these things evolve, as I said earlier, with lightning speed, sometimes we recognize that it may be inevitable that at some time we're going to have to deal with that situation. So we need to have those very, very clear procedures in place, so that we are meeting those, those indicate. So we need to look at what we need to put in place for both prevention and also the response to that. And that's one of the things that SOPPA, or what we have referred to historically as House Bill 3606, and those are important things for us to do in terms of what those step-by-step procedures are for a data breach. I think some good resources for that exist now is if you go to the Federal Trade Commission's website for implementing COPPA, the Children's Online Privacy and Protection Act at the federal level, they have sample step-by-step checklists, sample letters, and notices to be sent in the case of a data breach that I think closely align with the requirements of our state statute in SOPPA. What makes, I think, SOPPA a little more restrictive is, of course, there's some timelines for how quickly notices have to get out to parents and others if there's been a data breach. And those are factors that are important for us to keep in mind so that we are prepared for it. So when it happens, we can move quickly to end the attack, stop the further release of data, get things corrected and fixed, and then work on the notice to those who are required to get notice, and what needs to be included in that notice for those situations. And so I think it's really essential that we have in place those procedures, and those procedures both need to be what are there to prevent it, which in part is the big role of our acceptable use agreement and policy and our other data privacy rules that we're going to be putting into place. But then, of course, we need to have an unquestionably clear plan for a data breach. Have those notice letters, the draft and templates of those prepared, have a checklist for what needs to happen under the statute. And those are important things. And again, I think a great resource for that are some of the existing resources that exist for school districts in the COPPA guidance from the Federal Trade Commission. A question here. So is, I'm talking about whether a privacy officer is mandatory, may designate versus must designate. You're correct. The statute says, may designate, but somebody's still going to have to carry out all the duties and responsibilities. And so I think as you look at how that's going to play out, and when you look at what's been decided in terms of press policy and procedures as well. Again, I presume most school districts here are operating and using those procedures, that I think that's also the suggestion in the way that is there. And so whether or not somebody officially has the title of privacy officer, someone is still going to be required to carry out all of the duties that are set forth in SOPPA. And so when I say we must have someone who does that, in my mind, that should be the privacy officer. It's correct. Those duties could be divided up among multiple employees or people, or we don't need to add the fancy title. We can just call it the, it's the job of the superintendent, or it's the job of the assistant superintendent, or whoever it is. But the role has to be played regardless. There are things that must be done under the statute. And I think the best way to do that is to designate someone who gets the training and has the expertise to be able to do so. And so I think that's what it's there. And so, when we talk about may designate versus must designate, yeah, sure, the statute says may, but how are you going to do it otherwise? And sometimes I think we attorneys get a little too caught up in, the must and the mays, and rightly so when we get into litigation. But on the front end of advice, if I'm giving advice to my client, I'm going to say, okay, So you don't want to designate a privacy officer who's going to do all these things, and so I think that is that's important for us to think about in terms of those roles. And I'm going to come back to that a little bit more as we dig into our top 10 list, because as we get to the end of my list, we also want to recognize that we want to make sure that we also aren't putting everything on one person's shoulders, because that creates a weird set of responsibility as well. All right, number 7. We have to protect our passwords as the valuable assets that they are. Those are valuable pieces of information. And, I saw one guidance document that talked about guarding them like you would your wallet or your purse or the keys to your house. And I think they're even more important than that, right? In terms of the potential overall to do so. Yet I see so many people who don't protect their passwords in the way they should. And we can see this from, when I go into a school and I see, a nice little, sticky note with a password stuck right on the monitor, or the little notepad with the passwords right there on somebody's desk. Or I know, for example, if I ever need to get into any of my dad's bank accounts or financial accounts or his Netflix or whatever it is, I can just go right to his iPhone. He has no password or key code or face recognition because this is too much work. And I can go right to the notes on his phone and there's all his passwords. And I'm just like, I know it's difficult. When we create passwords that are, hard to remember, which is the idea, and that are unique, and we're not using the same password for everything, because all of that, again, makes us a little less secure. But at the same time, we need to do that in a way that is protecting them as valuable assets. And so all of our employees who have passwords into our network and system, which are our teachers, our secretaries, any other staff that accesses it, right? That might be our maintenance staff. It might be our coaches. It might be board members who have certain access to email and things, that we make sure that we are not, that they are not, and their use of our system failing to keep things protected, so that once someone gets into the system, if they know what they're doing, they can really wreak havoc and create some destruction and vandalism in those situations. And so it's really important that we are creating appropriate, difficult to crack passwords, and that we are protecting them and not making it too easy for folks to get in and be able to create problems for us, either through identity theft, hacking, or other types of data vandalism that happens. And so I think it's really important for us to keep that in mind. The other thing that I would say when it comes to passwords, and it's something I've had to learn over time. I mean, I remember, back in the day of my very first dial-up internet access, and I can still tell you what that password was because it was super easy, because it was my name, and I kept it my name for years. Now, I can share that with you because that account hasn't existed for 20 years, and I'm not too worried about it. And, I'm not dumb enough to still be using that my name as a password anywhere else. But a lot of us do that kind of thing. And so we need to be ready and prepared to do that. And I get the practicalities of it. Just this weekend, for whatever reason, my Apple TV is like, hey, you need to put in the password for your Apple ID again. And I'm like, oh, is it this? No. Is it this? No. If I try one more time, I might get locked out. And I get that's a pain in the rear. But those passwords are really important, and we need to protect them. Now, the other side of protecting them, and this is going to connect to what I'm saying at the end, is, but at the same time, we don't want it to be a situation where if someone, drops off the face of the earth, that now our system can't be operating, because there's not a way to be able to do that. And so we need to make sure that we have, the right system in place for that. Nothing is free. And I think that's a huge thing that we need to keep in mind when we're looking at legal issues and cybersecurity. When we are using a free program, it's more likely that we are paying for it, but we're paying for it with our data, with access to our system, or other types of situations, right? That's one of the key differences between a subscription-based Google-hosted account or suite and a free Gmail account. A free Gmail account isn't actually free. It doesn't cost money, it costs your data. It costs that you get advertising, and the advertising is targeted to you. That's why I can think about something and I get an ad for it in my Instagram feed or whatever, right? And so we recognize that nothing is free. We may be paying for it with things that create legal issues for us in the realm of cybersecurity. And so while oftentimes for educators saying that this app or program is free makes it more attractive, I think from the cybersecurity side of things, it should make us immediately skeptical about whether it's intended to be used in K-12 and it meets the requirements that we need to have for FERPA, for the Student Records Act, for SOPPA, for COPPA, and the other compliance rules that we need to keep in place. And so that's why it's really essential from my perspective that if something purports to be free, I'm going to have a little more cynicism and a little more skepticism and make sure that I'm properly investigating it before we get too far into the woods where we've created a security risk on our network because we've used something that was allegedly free, but isn't intended to or capable of running securely or safely on our network. And that's an important, I think, training reminder for educators when they're looking for things to download and use on their computers or on the network. So that's really important for us to keep in mind. Number 9, what I call the low tech security issues. There are all sorts of ways that we open ourselves up to some data privacy and confidentiality things that aren't just a high-tech hacker, trying to get into our system. When we share a device with our spouse or our children, when our devices are stolen. I mean, those are the kinds of things that I mean by our lower tech security issues. And so we can't let our guard down, particularly when we're working at home. If you're using a laptop that has a school district's IEP software preloaded on it, and your kids are also using that device to do their homework, and they can access the software, does that create an issue? Or, your spouse is using that laptop and they accidentally open a phishing email or download malware, and now it's opening up the school's network because you have access to it on your device. So we want to be careful about when we're sharing our devices with others, when our devices are left out in the open, when they can be stolen. Those are all factors that we have to keep in mind in those situations. And so other ways that or examples that I put in this same category, might be, again, just basic things like making sure that your computer, logs out after a certain period of time of inactivity and requires a password to get back into it, or the same on your device or phone, that it would require, that you don't have too long of a time if you walk away from your device that somebody else could sit down. All of those are important issues and things that we need to keep in mind in terms of what I think are those more, low tech. I mean, they're all still tech related, obviously, because it creates a data privacy concern, but it's not somebody from the outside getting in, it's somebody from the inside being able to get in. And those are things we want to keep in mind. And the other place where this has become an issue, and actually have seen school districts where students have had criminal charges for doing this is when a teacher leaves the classroom and leaves their computer open, and students can get in and see other kids' grades and other things. That opens us up to those security risks as well. So that's really important. So a question here with regards to transparency, the list of operators for SOPPA and posting on the website. For example, Google for Education, do we need to seek a new agreement or post the existing agreement that we had entered into initially? Well, I guess the answer to that is it depends on whether the existing agreement is SOPPA compliant and has those required security measures in it. So if your existing standard agreement you entered into when you initially signed up is compliant with the law, then that's all you need to post. But that's why I think the first step is getting that list of what those vendors or operators are. So then we can take a look at whether any of those need to be updated, and we can take a look. And again, like Google purports to be, and this is not meant to be a criticism of Google, but last year the state of Mississippi filed a lawsuit against Google because they said that their education suite doesn't have all of the protections that they claim to have. And so Google disputed that, and they resolved that. So, I think that we recognize that nothing in this area is super perfect, but we need to make sure that we are looking at it. So if we're simply posting the existing standard agreement, that might be fine. But what we also are tasked with is making sure that our agreements with those third parties meet the new SOPPA requirements. And then number 10, and I think this is an important one in my now getting closer to 2 decades of practicing law with school districts. I've seen too many problems that were created by what I call the one-person show. When there is one human being who has access to all the passwords, all the systems, and only one person. And that's been a problem where, let's say that person has a medical emergency, they're hospitalized, and no one else has the passwords. Nobody else can get into the system. Nobody else knows what to do or can fix it. Or I've also seen things where it was malicious, where someone who had that power and authority did things that were illegal or improper or fraudulent because they had the access. And I think especially as tech folks, that gives us a lot of power, and we have to make sure that we are using that responsibility and that authority appropriately. And so I think from that legal perspective, it's really important for school districts to have clearly outlined rules and expectations and job descriptions for folks, so they know what their role really is, that they're staying within the bounds of policy, and that there is, as part of that system and as part of the management of school employees, a process where we avoid the one-person show where one individual can, if they disappear or they do things inappropriately, that's not created a system that's more likely to have legal issues for us. And so it's always been my advice to make sure that in school districts, we've got more than one person that has the ability and knowledge to be able to access and fix things. Now, I'm not saying that means you always have to have 2 tech directors, but that there is a clear collaboration and understanding that in a situation where there was an emergency or other similar need arise, that someone else is going to know kind of where to find the information and how to be able to keep the system operating and to keep things going in the direction they need to go. And so I think that's particularly important for us, in the age of a pandemic, where if that person were to have to quarantine, if they were to become ill, that we've got the ability for our system to continue to run and operate and to continue to run and operate safely and securely, even if that one person was no longer able to be involved. And I think that that's a high and significant security risk for school districts and other entities, and one that we need to take seriously and really think about as we move forward and think through those issues. So that's my top 10 list. And so we've left ourselves here about 10 questions to just continue to do questions and answers. So, as we think about these legal issues that relate to issues of cybersecurity in school districts, let's have at it. Let's use this time to see if there are any questions out there for anybody. So feel free to add those here in the chat box, and we will figure out what we need to do and think about in that regard.
Awesome. Thanks, Brandon. Yeah, please do add any questions you have to the chat. Make sure also that you change it so that you're sending it to everybody, so that everybody can see the questions, and makes it easy for everybody to kind of follow along with what's going on. So please feel free to add questions now.
And as we wait a second here, if people have questions, I just want to, have a few more thoughts here for everybody. While you type your questions there into the chat box, I recognize that, there's a lot packed into those SOPPA requirements. And while certainly the intent today was not to get into the technicalities of those, but the broader legal issues in this time, I think most of us listening today are likely involved in this conversation because we're going to have some level of responsibility with that implementation between now and July. And I know there are a lot of resources through LTC and others for that get very specific. And so please make sure that you are taking advantage of all of those materials that are out there, because it's not going to be a small task for districts. And I don't want us to be on June 30th saying, okay, now we need to post these agreements to our website, knowing that there's a little more work to be done than just simply that.
Yeah, Brandon, I do appreciate that. As I mentioned a little bit earlier, with October being Cybersecurity Awareness Month, we are hosting a handful of webinars to kind of focus on cybersecurity, as well as SOPPA compliance. Just as a quick reminder, on the 13th, we'll be doing a webinar at 3:30 on reasonable security practices to kind of cover that aspect of SOPA requirements. And on October 22nd at 1 p.m., we'll be talking about the National Data Privacy Agreement for SOPA compliance. So there's a couple opportunities to learn a little bit more and take a little bit of a deeper dive into SOPA. So.
Excellent. Those sound like very useful. I would really encourage that.
Looks like we had a question pop in.
Question there, where do we determine or draw the line in terms of what vendors need to sign on the district contract addendum? I assume that means, when we're talking back to the statute and our compliance to making sure that they've got those reasonable security measures. And so, I think that when you say where we draw the line, I guess what we mean is, we need to make sure that meets the requirements of the statute that shows that they're meeting those reasonable security practices and data breach requirements that are contained in the statute. And so, without getting into too much detail on that, I think those are some of those things that will be specifically in some of those webinars that Brian mentioned to get into the details on those practices.
All right, we'll pause again here to see if we get any more questions come in. Make sure, like we mentioned, go ahead and type them in the chat box and submit them. Yes, thank you, Chris, for making that a clickable hyperlink. I get lazy and I don't put in the HTTPS, so thank you for that.
Well, not seeing any other questions. So again, I just appreciate everybody for listening, those of you who are live or those who are listening to the webinar later. And, hopefully this will steer us in the right direction to think about some of those big picture topics, to give some focus and intent to our planning between now and July to get all of those things in place for us.
Yeah, awesome. Thank you, Brandon. I really appreciate it. As I mentioned before, the webinar recording will be available here later on this afternoon. Hopefully after you saw this, maybe there are those individuals that you're going to be on as part of your team as you go through working through some of these things that you want to share this with. So please feel free to share that with them. And I also recommend you go back out and check out Brandon's webinar from September, talking about some legal issues revolving around remote learning. That was an awesome session as well. So I highly recommend you check out that and share those resources with your staff and your team as well. So Brandon, again, thank you so much for the information. Look forward to working again in the future.
Thanks so much. Appreciate it.
Thanks everyone for joining. Have a great afternoon.